Just to repeat myself for the recording, my name is Emma. I'm an attorney at Bay Area Legal Aid Health Consumer Center, and I'm here with Sarah Hart, who will be well, actually, I'm going to start with a quick overview of some immigrant eligibility, and then Sarah will take it away for the majority of our presentation. All right. Let me just go ahead and share my screen. Bear with me. So today we are doing part two of our training on healthcare programs in California with a focus on Medi-Cal. And yesterday we had some questions about more detail about the changes to immigrant eligibility in Medi-Cal. And I wanted to go over a little bit more information about that. Uh, so first of all, just to remind everybody who we are the Health Consumer Center. We are a free legal advice hotline providing free assistance on healthcare coverage and health access issues. We are also a source of advice, brief services, and extended representation. We aren't just the hotline. We also represent clients on health access issues of all kinds, including Medi-Cal, Covered California, Medicare, private employer insurance. We have no income or asset restrictions on our services. We serve the residents of several Bay Area counties listed on the screen. And we provide our services in all languages. We use a language interpretation service, and we are always free. So I wanted to briefly touch on immigration status and Medi-Cal because we know that this is a big, big question for folks. The landscape of eligibility status is, what immigration statuses make you eligible for Medi-Cal, and what are the consequences of using and having Medi-Cal if you are not a citizen of the United States? These are things that are changing rapidly. They're changing on the federal level, they're changing on the state level, and it can be bewildering and hard to keep track of. And I'm afraid because they are still in flux, there aren't any final answers here. But here's the current situation. If you are under the age of 19, if you are a former foster youth, and or if you are pregnant, the word pregnant seems to have migrated on this slide, but if you are a pregnant person, or if you are foster youth or in former foster youth, you are still eligible for Medi-Cal regardless of your immigration status. And that will not change in 2026, I should say. If you're older than 19, you will not be able to enroll in Medi-Cal starting on January 1st of the new year unless you have what's a qualifying immigration status. And on top of that, what is a qualifying immigration status will be changing over the course of the year from what it was previously. Folks who might remember pre-expansion Medi-Cal might be thinking, okay, I know about Pru-Call, I know about these categories, I know what used to be qualifying versus non-qualifying, I know the ropes. Actually, things are changing a little bit more than that. Um, if you are already enrolled into Medi-Cal, even if you have a non-qualifying status, you can keep your Medi-Cal by renewing timely and making sure that you don't miss any deadlines. As long as you are continuously eligible for Medi-Cal in every other way, your status won't kick you off the program. That's why the governor's plan originally called this an enrollment freeze, or an expansion freeze, but it's likely to cause the discontinuation of some Medi-Cal enrollments as well. Um, let's take a look at some more details here. So here are the statuses that remain eligible to enroll in Medi-Cal, even if you are a non-citizen. So if you're under the age of 19, if you are a current former foster youth, if you are pregnant, if you are a citizen, if you are a lawful permanent resident who has either met the 5-year waiting period or has become exempt from the 5-year waiting period. If you are what we call a COFA national, or if you are a Cuban or Haitian entrant. So again, this is less expansive than it used to be. This used to be a category that included more categories of immigration eligibility. this is a shorter list, and that's important to keep in mind. So this is full scope Medi-Cal with no share of cost and dental. These are the people for whom your benefits will not change at all, even if you enroll starting next year. Then, if you are in one of these categories, you will not have dental starting in July. And you may, starting in 2027, start facing a $30 premium for your services. So that would be lawful permanent residents who are not past the 5-year waiting period. That would be refugees, asylees, people who have been granted asylum, not applicants, but who have been granted asylum. U visa and T visa applicants and holders, VAWA residents, DACA recipients, and other PRU-call categories. PRU-call means permanently residing under color of law. It refers to folks who are known to be in the country by immigration authorities and have their removal deferred, but don't have what we might call an active status. And other undocumented people fall into this category. These who have uh, applications going before January 1st, 2026. So again, this is like if you are fully undocumented, you have no immigration status whatsoever, you don't fall into any of these categories, but you applied in December 31st of 2025 of this year, and you maintain your Medi-Cal through the year, this is what you're going to have by October of 2026, right? Full scope Medi-Cal, no dental, and expecting a premium starting in January. If you are undocumented entirely, if you have no qualifying immigration status whatsoever, you don't fall into any of these categories or any of the categories on the prior slide, you will only be eligible for what's called emergency Medi-Cal, also known as emergency and pregnancy Medi-Cal. This provides either emergency care or prenatal care and birthing care for folks who are otherwise ineligible. It can be a great protection, but it is quite limited. And that is what it was 2 years ago before this expansion took place. So that is going to be familiar to advocates who have been practicing here for a while. Emergency scope Medi-Cal is back and is not changing from what it was at that time. But yeah, that's for folks who have a non-satisfactory status in any way who apply after January 1st, 2026. Um, we the other question we get is how will the use of Medi-Cal affect my ability to stay in the country? And unfortunately, this is also a topic where there's a lot of confusion and uncertainty. Right now, Medi-Cal cannot affect citizenship determinations in most cases. It can't affect residency determinations in most cases. But that's current law, and the law is changing. Or I should say, the current administration has moved to change those rules. The current proposal would make receipt of Medi-Cal a factor in immigration determinations, meaning that you could be denied immigration benefits like citizenship, like naturalization, like a adjustment of status to becoming a resident, like other statuses. You could be denied these based on your receipt of Medi-Cal. Medi-Cal would be treated as what we call a public charge benefit. That has not yet taken effect, but it may be a change in law that is coming down the pike. The other issue is whether or not information used in enrolling in Medi-Cal will be shared with federal authorities. California must, by law, share information with the federal government in order to operate Medi-Cal. Medi-Cal is both a federal and a state program, and so information must go to the federal government for that purpose. Previously, before this last year, that information had not been used for immigration enforcement purposes, and that was not permissible. The federal government, again, has moved to change that, and there has been at least one such release of information where information was released to the federal government under California's information sharing agreement, and that was passed on to ICE, or I believe to USCIS, I should say. But the point is that this is not a theoretical risk. This is something that the federal government is genuinely actively seeking, and that information is much information is required to be shared. California is restricting that information as much as is permissible under the law, but that those restrictions are not very protective. So one point of interest is that if you have safety concerns of any kind that say that it's not a good idea or not feasible for you um, to enroll in Medi-Cal with your home address. You can use general delivery or you can use the social services county office as your mailing address for receipt of benefits if that's necessary. So we see domestic violence survivors do that a fair amount. People who are unhoused do that a fair amount, and other people for safety planning purposes may need to do that too. That does, of course, make it a little bit more difficult to get notifications about your case. But if you have access to a benefitscal.com account, it can, minimize risk without adding too much of an additional administrative burden. Something to keep in mind. I'm going to hand it back over to Sarah to talk about Covered California.
Thank you so much. All right, so now we're going to get into the weeds of some Covered California info. So Covered California, also known as the Marketplace, Obamacare, it's the state-based exchange program. And so generally that serves folks that are above the Medi-Cal threshold. So as we talked about yesterday, Medi-Cal for adults serves folks up to 138% of the federal poverty level, kids up to 266%. And for people that are above that, what are their coverage options if they don't have, employer-sponsored insurance or coverage from another source? That often becomes the marketplace coverage. And Covered California is it's not free. You have to pay for Covered California coverage. It does count as minimum essential coverage, so it covers, those same basic benefits. We'll talk a little bit about that. There are immigration status restrictions. We'll talk a little bit more about that as well and how those do and don't differ from the Medi-Cal restrictions. And then we'll talk a little bit about the subsidies as well, which have been in the news a lot lately. So you might be more familiar with them now than you ever have been. Um, and we can talk a little bit more about what that means for folks heading into the next plan year. So Covered California, baked into the marketplace plans is this idea of financial assistance. And so through 2025, that looked like subsidies for monthly premiums so that households were not required to pay more than 8.5% of their income towards their healthcare premiums. So that meant that a plan on Covered California was, while it's still expensive in many cases, generally a more affordable option that is expiring at the end of this year. And so I think that we have some more slides talking about that. But basically, what that means is that folks, especially folks, the state of California is putting in subsidies to help people in the lowest income brackets. Um, so people right above that Medi-Cal threshold will still be eligible for subsidies. So their, monthly premium amounts won't change all that much next year. But for people above, I believe the threshold is 200%. Might even be 150. I think that's on a slide coming up. But the subsidies will have expired, which means that people are seeing their monthly premium costs increase a lot. There's also something called cost sharing reductions, which are eligible for, we'll talk a little bit more about that, but it's cost sharing assistance. So it's money to help pay co-pays, deductibles, that kind of point of service cost that you would owe. And there's four tiers of qualified health plans, and they're, named these metal tiers. And so you've got the bronze, silver, gold, and platinum. And while they generally all cover the same like material benefits, the generosity of financial burden shifts depending on the coverage tier level. So, for example, for a bronze plan, you might have a pretty low or at least lower monthly premium, but you'll have a higher point of service cost. So, you might have a really high deductible plan, have a plan with $100 copay, just to go to a PCP, as opposed to a platinum plan where you'll see a much higher monthly premium, but little to no cost sharing at the actual point of service. So back to these APTCs. So it stands for Advanced Premium Tax Credits, and it is the subsidies that reduce the amount of monthly premiums that someone owes. So APTCs are paid directly by the government to the health plan, and then the consumer pays the remaining premium balance to the health plan. And the eligibility for the subsidy, so the amount of subsidy that you are, eligible for is based on your annual income. And, at the beginning of the year, people don't necessarily know what their annual income is going to be. You can estimate your annual income, and then if that changes, it's important to report those changes throughout the year. And that is because um, the amount of subsidy that you get is going to be based on your income. And at the end of every year, there's a reconciliation that happens. So, coming up this April during tax season, there will be a reconciliation for the 2025 plan year. And they basically reconcile and say, what was your estimated income for 2025? So what were you eligible for in subsidies? And then how much were you actually eligible for based on your reported income for the year? And so if you earn less income than you had projected for the year, then you get a tax refund. And if you earn more income than you projected, then you owe repayment to the IRS. There used to be a cap to how much is owed during that reconciliation time. So if you were under, I believe it was 400% of the federal poverty level, then there was a maximum amount that you could owe back in your taxes as part of the reconciliation process. That is no longer the case going forward. And then the other important thing, oh, it just slipped my mind. I was going to say one more thing about reconciliation. This is can be really important to change that, especially if you have fluctuating income. And so people that are self-employed or, client contract-based work, it can be really hard to estimate your income at the beginning of the year. So it can be really important to update that throughout the year so that your end of year um, income looks like what you actually projected that to be. So there's not a huge discrepancy there, and you end up with these really large tax burdens. And then the second form of financial assistance, this is something that we see, or at least we get questions on a little bit less, at least in on our team, are cost sharing reductions. To be eligible for cost sharing reductions or CSRs, you have to have an income below 250% of the federal poverty level. And really importantly, you have to be in an enhanced silver plan. And so the government pays these directly to the health plan, and it reduces someone's deductibles, coinsurance, and copay amounts. And the other thing with cost sharing reductions is that this is not subject to that same end of the year reconciliation process as we see with APTCs. And so we do see a lot of questions, especially during tax time when people are filing their taxes about the reconciliation piece, when things either go wrong or they're just not what they expected to be seeing on their tax bill, but these cost sharing reductions are not subject to that same reconciliation process. So who's eligible for Covered California? Um, Even if you're not eligible for APTCs or CSRs, so if you're not eligible for any of that financial assistance, you can still enroll in a plan and just pay the full price of that plan. Um, if you are eligible and receiving Medi-Cal and you enrolled in a Covered California plan, you would not be eligible for those cost sharing financial assistance mechanisms because you're receiving Medi-Cal. And so it's considered, financial assistance in two forms. But if you're between 100 and 138 and not eligible for Medi-Cal, based on the Magi income counting rules, which we talked about yesterday, you could be eligible for covered California. The immigration status is considered lawfully present, which, as Emma talked about, starting in 2026 is more restricted. Um, and you must not be eligible for other minimum essential coverage to most importantly, or the time that we see that become an issue most often is when someone has affordable employer coverage. And so affordable for this year, I believe, was considered 9.8%. And so that means that if you have healthcare coverage through a job or through your employer, and the monthly premiums are less than 9 point whatever percent is considered affordable, and that's a percent it's set at the federal level. It changes every year. Um, then you're not eligible for that financial assistance. If you have Medicare with premium-free Part A and enrolled in Parts A and B, or Medicare Advantage, as we talked about yesterday, Part C, or if you decline free Medi-Cal, as I mentioned, you're not eligible for financial assistance. So basically, you're not eligible for financial assistance if you are receiving healthcare in some other way. So the financial assistance is going to be a kind of last resort um, type option, or like last box on the checklist. And so whether someone qualifies for this financial assistance depends on the Magi household size and income of that household. We talked a little bit about this. This stands for modified adjusted gross income. And it's the household as reported on taxes. So this really mirrors the taxes as we talked about. Much of this program is run through that tax reconciliation. Um, and so generally the household income is the sum of each like household member's adjusted gross income. And so, a tax filer and their two dependents are a household of three. And so you would include all three of their incomes in that household. Two important things to note is that if a married couple, in order to qualify for financial assistance, they have to file their taxes jointly. So they can't be married filing separately. This sometimes comes up in couples when they're going through the divorce process. That can take a really long time. And so at the end of the year, they might be separated and wanting to file their taxes separately. But if they are still married, they would not be eligible for financial assistance unless they file their taxes jointly. There's a few exceptions to that, but it's pretty limited to that rule. But there's lots of different nuances and exceptions to different pieces here, and the household size and income calculations can be really tricky. And especially, like I said, if you're self-employed or your income's fluctuating throughout the year and you're bouncing back and forth between Medi-Cal. And so just something to note is that that can be a nuanced calculation. So when can you actually enroll in Covered California? So again, more changes. That's kind of the theme of this presentation, I would say. For this year, open enrollment started November 1st and it goes through January 31st. Starting next year, open enrollment is shortening and it will only be until December 31st. So that's a much more limited time frame right around the holidays. We expect that to be difficult for some people to make that deadline. Right now, it's a little bit more forgiving. But even still, you have to sign up by December 15th, which is basically 2 weeks notice for a new plan to start January 1st. Um, and the other thing to note on this piece is that California did restore the individual mandate effective in 2020. So that means that you have to have healthcare coverage or you pay a tax penalty. So if you don't sign up and then you realize, in 6 months that you didn't have healthcare coverage and you don't fall into one of these exemptions, then you will pay a tax penalty. One thing to note on that is that tax penalty, there's an exemption if it's period of 3 consecutive months or less. So if you just have a drop in coverage for 1 month, that won't be a problem, but it's for a longer period of time if you don't fall into one of these other exemptions. Some other exemptions do include like a hardship exemption, um, that you would have to, state your case for why you believe you're eligible for that, as well as a list of other things that are available on the Covered California website. The other time that you can enroll in Covered California is during a special enrollment period. And so if you don't sign up right now during this open enrollment period because you think, well, I have coverage, I don't need to sign up right now. But then there becomes a time, midway through the year when you are needing coverage. That doesn't mean you have to wait to enroll. That generally opens up what's called a special enrollment period. And so it is triggered by a qualifying life event, which includes like the loss of a job. So if your employer sponsored coverage ends, marriage, so you're now eligible to enroll, as a married couple, divorce, birth or adoption of a child, so you can enroll, a child in a health plan, or the loss of affordable coverage. For example, if you're no longer eligible for Medi-Cal, then you can enroll in Covered California. You don't have to wait until open enrollment at the start of the next year. And the enrollment period extends for up to 60, the special enrollment period extends for 60 days after the qualifying life event. And then some qualifying life events also allow enrollment up to 60 days before the qualifying life event, so you can prevent a gap in coverage. For example, if you know your employer-sponsored insurance is going to end at the end of the month, you can enroll in the middle of that month to make sure that your Covered California plan will start the first of the next month so that you can continue to have coverage without a gap. And you can apply online at Covered California, or by phone by calling their help center.
And I just want to add one thing that has come up fairly recently. Covered California is not making it very clear that open enrollment is available through January 31st this year. Their website it really encourages enrolling by the end of December, and implies that that's when open enrollment closes. It isn't. You can't get coverage for January by enrolling in January, except for in exceptional circumstances. But open enrollment will be open for an additional month. That change does not take effect until 2027. So, don't give up.
Yes, that is important. Their website does say, by December 31st, which is quite confusing. And so there's a few questions to kind of think through when you're thinking, can this person purchase a plan on Covered California? And so it's that first threshold of can they even, get through that first door? And it's do they have qualifying status to purchase a plan on the exchange? So I think this helps clarify that first slide where it goes through kind of all of those different qualifying factors. There's two main, buckets here is can they even purchase a plan? And so that is do they fit the immigration requirements and is it a time period in which they can enroll? So is it open enrollment or is there a special enrollment and period that will allow someone to actually purchase a plan? Then once you're through that door, then the second question is, does this person actually qualify for a financial assistance to lower the cost of Covered California? Um, and so that goes into some of those second categories where you have to also lack other minimum essential coverage, and agree to those tax filing requirements. Um, so again, can they purchase a plan, whether with financial assistance or at full cost, is um, a much broader population of people? Do they fit the immigration requirements? Is it a time where they can enroll? And then, especially going into next year, we'll see a much narrower group of people who are eligible for financial assistance to actually lower the cost of that Covered California coverage. So that is one, you're based on your income, and then, two, do you have other minimum essential coverage? And then three, do you agree to file taxes and file taxes in the way that Covered California requires you to, um, which includes that agreement to pay subsidies back if you end up not being eligible. So some examples here. So Sean has just been laid off from their job. They have employer-sponsored health insurance, which will terminate at the end of August. So what are some of the questions that you would want to ask to help determine what health insurance options they might have? Because right now you know that they are not going to have their employer-sponsored insurance, but there's a lot of other potential factors that you're looking at when you're trying to figure out what someone's eligibility might be. So the first question is, how old is this person? And if they're over 65, then they would be eligible for Medicare, and so Covered California would not be the appropriate place to go for that. Do they have any other health insurance coverage through, a spouse or through, some other type of coverage? Do they have any other jobs or sources of income? So if they are now laid off from this job or not working anymore, do they have zero income or are they still working in some other job or they still have other household income? And do those sources of income come with other types of insurance? Like if they're receiving SSI, then there's SSI linked Medi-Cal. Or if they're receiving SSDI, even if they're not 65, they could be eligible for Medicare. Um, Again, the income question, what will the income be for the month of August? One thing that becomes complicated with Covered California is that Covered California uses an annual income calculation and Medi-Cal uses a monthly calculation. So even if they had income in the past few months, if there's no income for this month or the months going forward, then they could be eligible for Medi-Cal in the next, coming months. And does this person have any disabilities or SSDI? So are there other programs that they might be eligible for outside of Covered California, even if they're not enrolled in those programs right now? So as Emma talked about at the beginning, and then as I mentioned as well, there's much more limited options for people um, that have that are undocumented. And so they cannot purchase, covered California plans even at full cost. So even if they have the funds and are willing to pay the full, 800, $1,000 monthly premiums that might be under covered California, um, then they still cannot purchase a plan through covered California. And Emma, isn't the DACA, that's changed, hasn't it?
Yes, unfortunately, that has changed. DACA was approved, unapproved, reapproved. Like it's gone
Yeah.
back and forth quite a bit. Unfortunately, DACA is no longer a qualifying status for covered California.
Yeah.
Mm.
Um, So one thing to note on that is that folks that are undocumented are exempt from the individual mandate. So that penalty that I talked about, where if you have a gap in coverage for longer than 3 months, then there's not that, penalty. Folks that are undocumented are not eligible for Medicare, and starting in 2026, unless they fall into a category like pregnant or one of those other categories that Emma talked about at the beginning, they're probably not eligible for new enrollment into Medi-Cal. So heading into next year, it's going to be a much tougher environment as we're navigating these waters. And before we go into the state fair hearing, I'm going to kick it over to Emma. I just want to emphasize again the enhanced premium tax credits ending at the end of 2020, 2025 going into 2026. I know there's been stuff in the news that they're thinking of passing it, but it wouldn't be eligible for January, and if that's even feasible. And so all of this definitely subject to change, but it's going to be a pretty dramatic shift in the amount that people are required to pay next year. So I think some of the stats were, going up like 97% increase in monthly premiums, and we've already seen like a drop in new enrollment in covered California plans. And for the people that are re-enrolling, the drop in silver plans and an increase in bronze plans, which are those plans that the monthly premium is less, but then if these people actually need to get care throughout the year, they're going to be stuck with higher bills at that point of service. And I think probably also a large increase in people that are just going to choose to go uninsured because that monthly premium amount is just entirely unaffordable when it's above, if they're not eligible for subsidies anymore and they're above the percentage that California is able to subsidize at the state level.
Thank you, Sarah. Absolutely. Um, so state hearings and appeals. So when you run into trouble with these benefits, if your covered California subsidies are calculated incorrectly, if your Medi-Cal is cut off, any state-funded or state-operated benefit, you have the right to appeal. Um, you can appeal almost anything that is a decision made by a state agency for what we call an entitlement benefit, meaning a benefit to which you would have been entitled if you were getting it correctly, and some discretionary benefits as well. And you can appeal application denials or delays. You can appeal terminations of your plan. You can appeal the action or inaction of covered California or a county. So they fail to process your application outside the amount of time that they're required to, or they just like don't act on your renewal at all and you are left in limbo. These are things that's appealable. The amount of a subsidy, if it is calculated incorrectly, the amount that your share of costs can be, as we discussed yesterday. You can also appeal issues with your plan in Medi-Cal through the state hearing mechanism. You can appeal Medi-Cal network adequacy problems. Am I able to see a doctor of this kind in a timely way? Am I able to see a doctor of this kind at all, or has my insurance company said that's not necessary? And many different other problems as well. The wrong gender marker on your card. You're not getting your documents in a qualifying language, etc. So the exceptions to what you can appeal are non-particularized determinations. What that means is when there is a policy change that goes across the whole state or the whole country, that's not appealable. So, for example, when CalFresh got cut off in if due to the shutdown, they had to put a big sign up on the website, the first aid appeals, saying, "We cannot issue you these benefits. This is not an appealable action. No one has decided to turn off your benefits specifically. This money just doesn't exist." Those are not appealable decisions. We would recommend that you request a state fair hearing and appeal any adverse action that you receive within 90 days from the notice of action, or if you have a denial of healthcare services. So, like I said before, you can't see a doctor, or they're saying you're not eligible to see a doctor. You can file those appeals within 120 days from the date of the plan's denial of your appeal to them. If you submit an appeal before the action goes into effect, you will keep getting your benefits until you receive a final state hearing decision. So if you get a notice of action saying your Medi-Cal is being cut off at the end of September, but you file for a state hearing in August, the notice has not yet taken effect. Excuse me, you still have time, and your benefits should continue until after the hearing. We do see cases where if you file for a state hearing asking for aid paid pending very close to the date that your benefits are supposed to be cut off, um, this is a manual county action. They go back in and they turn your benefits back on, right? Like this doesn't happen automatically. And so if you don't file for state hearing with a lot of lead time such that they can, avoid ever turning it off, you might find that it takes a little while for it to come back. That is most relevant for folks who get well, it can be quite relevant for Medi-Cal recipients, but we see it most often as an issue in in-home supportive services cases where people say, listen, I requested aid pay pending, I was granted aid pay pending, my request was made in time, but I still can't, my worker isn't getting paid. In that case, you might need to contact the county and say, hey, speed it up. We got to turn this back on. The other issue to keep in mind with aid paid pending is that some counties will send you a notice of action saying your benefits have been restored. That's because your benefits have been restored. So let's use the example we've got here. Your notice of action turns your Medi-Cal off September 30th. You file for a state hearing August 16th. They drag their feet, they turn off your benefits, they slap their forehead, they realize, oh my God, there's a hearing request, and they send you a notice saying, okay, we've gone in and we've turned on your benefits. That notice does not say because you requested aid paid pending because the hearing is going on. It just says we've turned your benefits back on. So you get that notice and you say, oh, I think the problem's been solved. I'll withdraw my hearing. Do not do this. Make sure that your problem has actually been resolved and that you are not just getting aid paid pending. Another issue that we hear a lot about is whether or not aid paid pending needs to be repaid to the county. In the case of covered California subsidies, benefits that are paid out during the appeal process may be clawed back during reconciliation, right? Like if you are overpaid benefits, you're overpaid benefits. So if you keep your aid paid pending on, but you lose the hearing for covered California subsidies, when you do your taxes at the end of the year, you're going to have to pay those back. That does not apply to Medi-Cal or in-home supportive services. Once you file for that state hearing, you're good to go. Your benefits will stay on. And even if you ultimately lose those benefits, they will not ask you for the money back unless you have been found to commit fraud. So this is a really important protection in the Medi-Cal context, and it's definitely worth keeping in mind. A state hearing is a formal phone call under oath, is the way that I describe it. There are different ways that you're allowed to have a state hearing. You can have a video call. You can go in person. In the Medi-Cal context, those hearings are often in Sacramento, so it's worth considering whether or not you really need to go in person before you request that. But the majority of these cases are by phone, and that is the standard. It's a conference call. The administrative law judge, who is a high-level employee of the Department of Healthcare Services, or sorry, of CDSS, of California Department of Social Services, will call you, will call the county, will call in any witnesses or translators you may have, and monitor the proceedings, and determine and place you all under oath and ask for your testimony on events. Beneficiaries can absolutely represent themselves. And in fact, many people do and win. There's no reason that in theory that you can't, but it can be an overwhelming and confusing process. And if an advocate can assist them, it's a huge, huge benefit, especially in complex cases like in home supportive services issues. You have the constitutional right, to present your case, to provide oral testimony, and to submit relevant documents or other forms of evidence to support your case. If the issue at hand is complex, we definitely recommend sending anything that you might have to support your case in advance so that nobody's reviewing it on the call. If you have a statement of position that you might want to write up, you can submit that as soon as, the night before the hearing if you're the beneficiary, but you want to make sure that the other side has had a time to review it, and you don't want to have to continue the case so that they do that. So the earlier, the better. Meanwhile, the county or the managed care plan or covered California, they also have the right to attend, and they are required to provide you any statement of the case a few days before the hearing so that you have time to review. After the state fair hearing decision is released, which is usually a couple of weeks after the hearing, but can be sooner, there is a 30-day deadline to appeal. The mechanism for appealing is called a rehearing at the first level. And you can say, I disagree because I think they got the facts wrong, or I disagree because I think they got the law wrong, or I disagree because the county, I have new evidence, I have something else that's come up. But you must be able to demonstrate why you think the judge got it wrong. What is the evidence that you have to show that the judge got it wrong? It's not enough to just disagree with the decision. You must be able to explain why the judge's decision was incorrect. Um, if the rehearing is granted, the case will be set for another hearing with another judge who did not participate in the first decision, and the whole thing will happen again. It's exactly like a hearing. It's the same thing. You go to another hearing on the same case with a different judge. Again, the judge will issue a decision, and at that point, the decision is whatever decision comes out of that would be final. You can appeal at further levels by filing a lawsuit in Superior Court. It's called a writ. That is very difficult, and I don't think too many people successfully prosecute a case of that kind on their own. It is that is a highly legal process. I mean, it's a case in Superior Court. Excuse me. It is best to avoid that at all costs, and to therefore prepare well for your state hearing if it is at all possible, because your second bite at the apple can be much harder. You have a year for in Medi-Cal cases, and in specifically, you have a year from the date of the decision to file in Superior Court. I just want to stress that that is a Medi-Cal specific appeal to timeline there. Um, I'm going to talk a little bit more about appeal rights in the Medi-Cal and Covered California context before I move on to some problems for Medi-Cal for the unhoused. I want to also note that we've been talking about state hearings here. You also have the right to appeal to the Department of Managed Healthcare, which is the appeals agency that governs Medi-Cal managed care plans and Covered California managed care plans and other California regulated plans in many counties, not in all counties. So you always have the right to appeal plan decisions by your Medi-Cal plan to California Department of Social Services through this process. And if you are in certain counties, including Santa Clara County, including Alameda County, including San Francisco County, not including any of the northern counties of the Bay, you have the right to also appeal to this other agency because your plan is regulated by that agency as well. That agency oversees decisions made by your managed care plan for managed care benefits. So what that means is your ability to see a doctor, your ability to see a doctor in the right amount of time, your ability to see a doctor close to your home. And we do recommend filing a complaint with the Department of Managed Healthcare if you have a DMHC regulated plan, as well as going through the state hearing process if that is feasible. Um, the decisions made by the DMHC, this other agency that I'm referring to, are not binding on California Department of Social Services state hearings, but the reverse is not true. So if you have the state hearing decision first, that's the end of the story. That decision will become final. I want to talk about some specialty topics for Medi-Cal for the unhoused. Um, People experiencing homelessness often have unusual issues using Medi-Cal because Medi-Cal is not designed to be used in multiple counties. And people who are homeless may have multiple counties that they call, that they call their own, right? Um, they must select one county as their permanent residence, and in that county, they must receive all of their benefits. So let's say that you live you live in your car and you move regularly between parking in Santa Clara County and San Mateo County, right? You're on the border. You're in Mountain View, you're in Palo Alto, you're in East Palo Alto, what have you. And you are not sure, there's no single truthful answer to what county do I live in. That's not a question that has a meaningful answer, right? But you spend most of your time in one or the other. If you choose to get your benefits in Santa Clara County, you must choose to get your benefits from Santa Clara County Family Health Plan, sorry, Santa Clara Family Health Plan or another Medi-Cal plan in that county. You must choose to also get your food stamps or your general assistance or your CalWorks or your in-home supportive services. You must get all your county benefits in Santa Clara County. So you can't get San Mateo County food stamps, but Santa Clara Family Health Plan doctors, you can't participate in two counties at once. You must select one county and stick with it. You can move between counties. That's called an inter-county transfer. That must be completed fairly rapidly. They have 30 days to process plus until the start of the next month. So if I applied for Medi-Cal, a county transfer between two counties today, the other county would be required to make a decision on that transfer by January 19th plus until February 1st. So I would need to be in the new county by February 1st at the latest. Um, if you've been in San Mateo County, you've been getting your doctors in San Mateo County, but your permanent residence is now Santa Clara County for healthcare purposes, and you're now in a managed care plan, um, you may need to keep seeing doctors out who are now out of network, who are not in your plan. maybe you travel between multiple counties for this, and you have a pulmonologist in San Francisco who you absolutely have to keep seeing. There are legal protections in place to make this possible, and it is sometimes possible to continue care in that context. We recommend calling us for further advice on this topic, but the bottom line is you would request a network exception from your plan to say, here are the good reasons that I need to be able to see this out of network provider. And for various different possible reasons, that may be an option. Another issue that comes up for the unhoused specifically is proving residency. California has loosened its rules on this in a very helpful way. If you don't have a mailing address, you can get a letter from a homeless shelter or another public or community service agency that states that you're getting services from that agency. So you can get a letter from Operation Dignity. You can get a letter from Bay Area Legal Aid. You can get a letter from SourceWise, whoever it might be. As long as that agency is a homeless services provider, they can send a letter on your behalf saying to the county to confirm, yes, we serve this person in this county. Counties are required to accept your evidence for Medi-Cal eligibility over the phone, not necessarily in writing, unless there is some, strong evidence to the contrary. The exception is citizenship or immigration status. They're not allowed to take just your word for it in that regard. But for, do you live in California? They can take your sworn statement over the phone. What is your income? My income is zero. They can take your sworn statement over the phone. They are required to accept that for Medi-Cal purposes. Um, it can be difficult to get notices if you do not have a fixed address. And we talked about this before, right? There is a protection that allows you to receive your mail through general delivery, or to pick up your mail at the county office, the county social services office. We would recommend that if it is feasible for you to get your mail at a PO box, or at a family or friends, and you have somebody who you trust to take your mail, we would recommend doing it that way. The reason being, general delivery and the county office does come with a risk of mail getting lost, and that's just unfortunately a fact of the matter. There is no rule that says that your mailing address needs to be your residence address. In fact, it's quite common for folks to have a mailing address that is not their residence address. You just need to make sure that the county knows what information you are giving them. There are issues sometimes when a county gets confused and says, oh, okay, so you're using this mailing address that's in Oakland. I guess you must have moved to Oakland. Just make sure that they understand that that's not true. State hearings are generally by phone. If you are unhoused, that may be an issue because you may not be able to charge your phone. You can get an in-person state hearing on request. Like I said, those are generally up in Sacramento for the Medi-Cal issues. For other issues, you may be able to do that locally in your county. So it's up to you what you think is most convenient, or if you need to set up a time to, use an agency's phone or something like that, that might be the way to go. You can get your information rather than by mail. You can get it by email. You can even create an account on the web portal, which will have all of the information about your case listed, as well as all of the documents listed so that you can download them and review them for easy access. For renewals, you can request disability accommodations for this under the Americans with Disability Act, but also under California's Medi-Cal policies. You can ask for more time to provide additional documents or to complete a renewal. Very legal to do this, and we really recommend that you do it if it is something that you need. Um, like I said, you are able to provide information about your case verbally and give a telephonic signature. The exception would be if there's some contestation. So, for instance, you tell them your income is zero, and the IRS comes back and shows your income at $100,000. They may require more information to verify that your income is in fact zero, but generally speaking, a telephonic signature is sufficient. And there are many, many, many different ways that you can provide renewal information. It is not just I have to walk into the county with these physical documents, and that is important to keep in mind because a big source of issue is how do I get all my renewal information in? And like, how do I make sure that the county gets contacted? Especially now when it is often so difficult to reach county hotlines, unfortunately, because so many of them are understaffed and the phones just ring through. I would recommend creating an benefitscal.com account. That can be a good way to reach folks. I would recommend going to county offices in person when possible, but you can also communicate with the county via mail and via fax. It will get through, it's just slower. So we want to talk about some, slightly messier situations, to give you a sense of how this stuff plays out in reality. And let's talk about our friend Cy. Cy is applying for health benefits through Covered California. He's 45 years old. He is unmarried and he is not disabled. He has $138,000 in checkings and savings combined. He makes about $1,200 a month per month in employment income, and he has no other income. What health program would he be eligible for? So we have size income, which is 1,200 a month. We have size assets, 138,000, and we've got his age and health status. So in chat, why don't you give me a sense of what folks think? I'm seeing one vote for Medi-Cal. What do other folks think? Somebody's saying not Medi-Cal because of assets. And covered, I'm seeing a bunch of covered California, a couple of covered California. Okay. Um, and Juliana suggesting lowering his checking and savings amounts to 130. Actually, Cy is eligible for covered for Magi Medi-Cal. The asset limit is coming back in 2026. You guys are all you have your eyes on the prize. You are absolutely correct to think about this, and you're doing the right thing. But Cy isn't disabled. Cy is under the age of 65, and his income is considered under the Magi Medi-Cal program. There is still no asset limit for Magi Medi-Cal, and so Cy is actually Medi-Cal eligible. Nam was right. Um, if Cy's income was through SSDI, if he was receiving disability based income based on a federal determination, he would be eligible for non Magi Medi-Cal. And yes, that asset limit would come into play. He should have Medicare if he's had SSDI eligibility for more than 2 years, or he can enroll in Covered California if he doesn't have Part A eligibility through Medicare. So the folks saying Covered California were right in that circumstance. But Juliana's answer is, I think, the most correct of all of the non-Medi-Cal answers, because absolutely, an $8,000 spend down should be pretty easy to accomplish and would result in less than a month's worth of long-term care disability, even if you do it next year. So it would be good for him to spend down below the amount if he fell into the non-Magi category so that he can maintain his eligibility for Medi-Cal, which is going to be a lot cheaper for him. So here's a new situation. We've got Mark, Min, and their kids, Missy and Molly. Mark is applying for Covered California benefits. Who is in his tax partner, tax household? Mark and Min are not married, but they are joint children of the household. Is it all of them? Is it just the kids? Is it only one of the kids? Who's in Mark's household? Michelle says, however he files his taxes. I'll tell you that's a strong start. It's not the whole answer, but it's a strong start. Um, Menon, I'm going to answer your question in just a moment. Um, so for Covered California and Magi House Medi-Cal programs, your household is your tax household. Nam is correct. In it is required that that your minor child who you claim as a tax dependent be part of your household, but that assumes that Mark does claim his minor child as part of his household. Um, so Mark and Min would each apply for their covered California households, and their children could be included in the household of the parent who claims them as dependents for tax purposes. Molly could even be in her whole own household. So it's not quite true that Mark can claim anyone he wants, but it is true that Mark can really arrange this to his satisfaction and to Min's satisfaction, and that they can divide the household appropriately amongst themselves. Let's see here. Okay. Menon, I'm going to answer your question in the course of answering this question. Sally is 59 and receives SSDI in the amount of 1,500 per month. She has had Medicare and free aged and disabled Medicare, well, for years. She then becomes eligible for pension income of 475 per month, and the county has informed her that her Medi-Cal has been assessed a share of cost of 1190 per month. She cannot afford her medical care with the share of cost in place. What can she do? So this is a refresher from yesterday. What are some options for Sally to reduce her share of cost? What are some ways that she could do that? Kat, starting really strong, she can indeed purchase a premium to spend her income down below the amount. That is one correct answer here. Any other suggestions? Yes, the Working Disabled Program. Thank you, Anna and Juliana. You guys are dead on. The Working Disabled Program is a great suggestion for Sally. Most of Sally's income is through a disability-based income, which means it would be exempt for the Working Disabled Program. If she's able to go back to work even a very tiny amount, even $1 an hour, 1 hour a month, she can apply for the Working Disabled Program, have most of her income discounted, and comfortably go back to free Medi-Cal. But Kat's answer is also dead on. She can also find an inexpensive health plan and deduct her premium from her income. She might want to do that, quickly because we're in various different enrollment periods now. Also, it's important to remember that this is only something that affects her Medi-Cal. Her Medicare will not be impacted, um, but the indirect effects could be substantial, right? If she's Medi-Medi, if she's got Medicare and Medi-Cal, first of all, if her Medicare becomes non-free, if her Medi-Cal becomes non-free, she will no longer have her Part B premium paid by Medi-Cal. So that money will come out of her check, $185 per month this year, going up to 200 next year. Then her out-of-pocket expenses will increase because Medi-Cal will no longer be paying the backstop of her appointments with her Medicare doctors. And so she will still be facing that, 1175 share of cost in potentially, you know, could be every month depending on the level of her healthcare needs. So on the one hand, it's not an emergency. She'll be able to keep seeing her doctors and normal. And on the other hand, she may be facing increasing costs, and it's important to try to address it anyway. So I want to go back to Sally and talk about a slightly different situation here. So just to answer Menon's question, if you're covered under Covered California and you will be 65 in the middle of 2026, will they switch your coverage to Medi-Cal? Do you have to contact Covered California to inform them? This is a great question. What you need to keep in mind with Covered California is not Medi-Cal eligibility. It is Medicare eligibility. If you are turning 65, you will become eligible for Medicare Part A for premium free in the majority of cases. Not quite everybody, but most people who are eligible for Covered California are going to have premium free Part A just because that's how sort of the income math works out. So if you're working, you're making 80,000 a year, you're on Covered California, no problems, and then you turn 65, suddenly you have Medicare Part A eligibility and you are no longer eligible for Covered California subsidies because you are eligible for Medicare Part A. You do not need to inform Covered California that you are turning 65. Do need to terminate your health insurance. Covered California will inform you that you are turning 65. You will get letters in the mail saying, you're turning 65. You're getting older. You need to make sure that you terminate this coverage before your Medicare eligibility takes effect. And this is true even if you don't enroll in Medicare right away. You definitely should enroll in Medicare right away. You don't want to be hit with any late enrollment penalties. But even if you mess up and you miss the window, you will still lose your eligibility for subsidy for covered California if you have Medicare Part A eligibility. So you are uh, you are in a position where you are not able to get covered California. You're not able to get Medicare because you're, waiting for open enrollment or what have you. Or you have your covered California, but it's costing you full price. You can terminate it anytime you want, but you may have several months of full price coverage that you're now on the hook for, and nothing to be done about it, I'm afraid, because like I said, covered California does send you those letters, and if you didn't excuse me, if you didn't open them, you're going to be out of luck. We do see these cases infrequently. They're pretty good letters, but they happen and they are quite punitive. Now, the question is, can you transfer over to Medi-Cal? So in the case of somebody like, well, Sally's a bad example. Let me go back to, let's see, to our guy, Cy. So let's say Cy was making 1,900 a month rather than 1,200 a month, right? And Cy aged out of covered California eligibility, became Medicare Part A eligible, he would be sent over to, he would not be sent over to Medi-Cal for assessment because of his assets in this example, right? But if his assets were below the limit, he would be sent over to Medi-Cal for evaluation at that age. It would be best, however, for him to terminate his covered California plan proactively because it doesn't happen automatically and apply for Medi-Cal separately, and thereby get Medi-Cal with no share of cost because his income is close to the line in that example. Um, Anna asks me, I have assisted with applying for Medi-Cal when there's only a Part A. Wondering what the rule is on Medicare Part B. Is it mandatory for the applicant to attain Part B to obtain Medi-Cal? I Yes, it is you are required to apply for, actually bear with me because I'm second guessing myself. It is required that you apply for all forms of free health insurance that you are eligible for. So if you are eligible for Medicare Part A for free, you have to enroll. If you are eligible for Medicare Part A paid, you do not have to enroll. Uh, for Part B, this question really, really virtually never arises because it is so much more advantageous to be on Part B. Right. Yeah. Part B usually you have to pay, but the thing is, if you're eligible for free Medi-Cal, Medi-Cal will pay for the Part B. So it becomes free immediately, right? Under Medi-Cal rules. That's why I'm hesitating. I maybe Sarah can double check for me. I think you may be correct that you can opt out of Part B, if it is more advantageous for you. It really virtually is never a good idea to opt out of Part B. The late enrollment penalties are very real. The it is quite common to be able to spend down such that your Part B premium does get covered. Um, I see. Okay. In the veteran context, right? We don't actually handle a lot of veterans because we have a limited veteran practice. Um, that would make sense that the VA benefit duplicates the Part B and thus makes it less advantageous for them. In the majority of cases, that's not going to be a good idea. I think veterans may be in a slightly different position because it is such a similar benefit. We'll come back to you on whether or not the Part B is required. You may be correct that you can opt out, and we'll let you know very shortly. So let's look at example 4. So Joseph is 67, a single person, and receives $2,275 in Social Security retirement each month. His insurance is Medicare, and he pays $185 a month in Part B premiums and $60 in vision and insurance. He has $1,800 in his checking account. So let's do the math. With 1,801 per person, um, as your free full scope share of cost Medi-Cal, no share of cost Medi-Cal number, does Joseph qualify for Medi-Cal this month, right now? While folks are thinking, um, Nam asks, can undocumented immigrants apply for Medicare if they've been paying for Medicare tax during working years? No, Medicare is a very strict immigration-based eligibility program. Undocumented immigrants cannot apply for Medicare. Kat is correct. He is over the income limit for free full scope Medi-Cal, and he would have a shared board. So maybe I'll just leave the math up on the screen while we discuss, because the next slide is just leaving time for any questions to be asked or to go back over anything that folks find confusing. So if folks want to review, here's how you do that share of cost math. Yeah, any questions for anyone? Cynthia.
Hey, I have a question. I work with a lot of mixed status families,
Hmm.
and then a lot of them parents doesn't qualify for medical because income, but kids qualify.
Hmm.
But now with this, knowing about public charge, any advice for those families? Because I know people are saying, they shouldn't be doing that because public charge. What about if they want to legalize their status? Yeah.
So let me put it this way. How do I put this? There is no right answer at the moment, and that is on purpose, right? Like the these policies are currently being designed very explicitly and intentionally to encourage uh, immigrants to not use public services and potentially self-deport, right? Like that is the explicit goal of these changes. I don't think I'm talking out of turn when I say that. That means that these catch-22s are also intentional, right? Like it feels like you're being forced to make an impossible decision because people are being forced to make an impossible decision. That is the goal. So the issue here is that um, if you need medical services, yeah, I mean, like there is a risk associated with, potential public charge. Again, like the current rule would certainly not allow the imputation of the receipt of benefits from one member of the family. Like you're talking about mixed status household, right? Like under the current rule, if your kids have Medi-Cal but you do not, that's not imputed to you for public charge purposes. Uh, I believe that is one of the things that the proposed regulations are seeking to change, right? And certainly that is a potential change that could happen in the future. And so the question is, will that be considered retroactively? Again, under current rules, it shouldn't be considered retroactively, but we don't know what's going to happen. And there is this affiliated risk. And so what I would say is there's no right answer. There's just the answer that is right for the family in question. If you need medical services and you can't afford other forms of health insurance, California makes this health insurance available to you for a reason, right? Like, this is under California law, you should be using this insurance. Your taxes are paying for it. You are paying into it. But if you are questioning, what will be the consequences be for me down the line, unfortunately, that question is just not answerable right now. We just don't know. If the law doesn't change, there will be no consequences. If the law does change, which seems very possible, then there will be consequences. And it's not possible to plan for that kind of situation, I think, without just making decisions based on like, okay, well, what is the level of need and what is the right decision for my family? There are a couple of non-public benefit programs available. There's a county health insurance for undocumented folks who those programs sort of went into hiatus during the expansion period. Um, and are now sort of ramping back up just because very few people were eligible for them and needed them, and now they're coming back. So in certain counties, I know like Healthy San Francisco never really went away, but I think the other plans may have sort of like wound down to some extent. And it might be difficult to reach the folks who run them, but they exist. They are options, and they are not public benefits. The Kaiser is offering a sort of what's called I think it's called the Kaiser Community Plan, that allows you to enroll in those plans during open enrollment. That is a paid health plan. You are not receiving a public benefit. It's just not very expensive. So those are some options. But if you are truly not able to afford those options, then you may need to make some decisions. I wish I had a better answer for you. I'm sorry. It's just a very difficult situation. Health plan of San Mateo. I actually do not know. We don't serve San Mateo County directly, Michelle. So our colleagues over at Legal Aid Society of San Mateo are the Primary Health Consumer Alliance affiliate there. So I don't know what the ACE program is. Will you tell me what that is?
Yeah, Alameda County has one too. It used to be called Health Pack.
Yes, got it. Yeah,
It's yeah, basically you
right.
help
The
low
county
cost
health
health
plan.
insurance for preventative care. For
Yes. I mean, they're required to carry something like that, right? Like all the counties are required by California law to have such a plan. And this is what I meant when I said some of the counties are sort of being slow to spin those back up. Health Pack is what I was thinking of in Alameda County. Um, to my knowledge, Alameda County is bringing that back. Also, to my knowledge, I don't know anyone who's like recently talked to them. So they are required to be operable. This is California law, and it didn't change during the expansion. So each county is required to have some kind of plan, but whether or not it's coming back in the exact same form, I'm not sure.
Thank you so much. This has been very informative. I appreciate you guys putting this on for us.
We're really happy to help out in this way.
Can
I
I?
also want to talk just for a moment, just to talk about county health plans. If you operate in the Bay Area primarily, the all of our local county health plans for this population are pretty good. Like they very varying different levels of pretty good. Like Healthy San Francisco is like the same as Medi-Cal in San Francisco. It's just a little expensive, but a little more expensive, I should say. But the health pack was pretty good when it was operating. Stuff like that, right? If you operate in other counties, what they've spun up as a health plan, it isn't always a direct alternative to health insurance, right? Like you might get a voucher to pay for care, and it might be very time limited. It might, it's sort of like general assistance, like in that way. So if you operate in a non-Bay Area county, you may run into some pretty small scale programs of that kind. That's probably an area where it would be great if those could be expanded to just get more health access. But it is up to each county how they want to design those programs.
I have a question.
Yes, absolutely.
Are you working for the county and you are doing this service free? The reason why I'm asking is I volunteered a couple of times for homeless people, and then that's why I think that's through that email chain I get this, and I'm participating to understand, not for me,
Sure.
just for other people, but. If you are doing that to help people who's less fortunate, and it's just I'm wondering what is another avenue you have to help others? Meaning, if you are homeless, do you have a time like a computer to sit down and do like we're doing right now? What is the other different avenue you guys are trying to support the homeless people for them to get this information?
Thank you. Great question. So we are both attorneys at Bay Area Legal Aid Health Consumer Center. We do not work for the county or for the state. We are independent attorneys, part of a nonprofit agency. We work for Legal Aid. We're a member of the Health Consumer Alliance, which is a statewide network of agencies of this kind. And we are not affiliated directly with the county, with any particular county. And we're not volunteers either. This is our job. We do it full time. We are providing this training primarily for service providers. This is mostly for folks who help out folks who work with the homeless, but it is of course available to everyone, and
Yeah.
that's not a bright line division. Lots of us will have both experiences over the course of our lives, and so we like to make sure that our trainings don't assume that nobody who's at the training has ever experienced homelessness themselves, because that's not true. That's usually not true. That's if the language I used there was confusing about the intended audience of today's training, that might be part of why. We we would be happy to come into local. We do live versions of these trainings in person when we're invited by local agencies, and we try to reach out and provide them more often. If you have a particular community center or anywhere that would like to host us to give such a training, send me an email. I'd be happy to set something up. We can do that in any of the counties we serve.
Would you provide me your email address, please?
Yeah, it's on the PowerPoint. It's at the end of the
Okay,
PowerPoint.
thank you.
You
Appreciate
can
very
also
much.
email Homebase to be connected with us.
Okay, thank you. Appreciate very much.
Yeah, and then I'm seeing some questions in the chat about spousal impoverishment, Medi-Cal, and spending down.
Yeah, I was
Excuse
gonna
me,
say,
just
Emma, on some of the spend down stuff, I wanted to clarify there's two versions of spending down that we could be talking about here. So one is when you're looking at the countable income, if you're trying to spend that down below the 1801 or the updated Medi-Cal eligibility threshold to have someone in like free, full scope Medi-Cal eligibility continuously, that needs to be a monthly medical premium that you're spending that down with. However, if that's not an option, for example, if someone has, if they're just $800 over that threshold. So it's not feasible to buy a plan that's going to be $800 per month and spend it down in that way. And so someone does have a share of cost, then you're in the share of cost spend down. So that is when you are paying for healthcare services that goes to reduce your share of cost. So that works more like a deductible. And so that is like if you go to the doctor, any copays, um, that type of cost sharing, stuff like that is going to be used to reduce your actual share of cost. So those are the two different kinds of spend down that are there. But unfortunately, generally, no, like the IHSS spend cannot be used to spend down either your countable income or your share of cost in most cases, though there's, some nuance there. So that's one thing I wanted to just say verbally on that. I don't know, Emma, if you have anything else to add.
just that I see that there was a follow-up question as well about like whether or not spousal impoverishment Medi-Cal applies to IHSS. In fact, that is kind of the number one way that we use spousal impoverishment Medi-Cal in our practice. Yes, 100%. IHSS counts as nursing home level care if it is over a certain number of hours and provided in a certain way. No need to get into the details there. If you are thinking my client, my family member, I need care that would be equivalent to what somebody might get in a nursing home in order to stay safely in my home, please, 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 please use the magic word spousal impoverishment while you are applying for Medi-Cal and while you are asking for IHSS, and do not let them tell you it's only available if you're in a nursing home. That's not true. That hasn't been true for a decade, and yet we still get those calls.
And one other thing that I'll add back to the Medicare, I can't find a very clear like regulation where it says you have to be enrolled in Medicare Part B to receive Medi-Cal. But from the VA perspective, if someone's going to be eligible for Medi-Cal, it would behoove them to also enroll in Medicare Part B. I know people put that off so that they don't have to make those payments. But you can be enrolled in VA, benefits, healthcare benefits, as well as Medicare Part B, that it just like allows you basically a broader network of care. And if you're going to be eligible for Medi-Cal anyways, then Medi-Cal will pay for those Medicare Part B premiums. So I don't know if that specifically answers the question of do you have to have Part B to obtain Medi-Cal, but to
I
Emma's
think,
point,
yeah, I think I've pulled up that. So if you are applying for Medi-Cal because you are over the age of 65, you are required to apply for Part B. If you're applying on the basis of blindness or disability, you don't have to because it's deemed automatic. Um, because you have SSDI Title II. And if you don't have SSDI, then you have to apply for Part B. And if you're getting dialysis, it's deemed automatic. So yes, unfortunately, there is a requirement to apply for Part B. And I just like totally second everything Sarah said, that like it is really it can really hurt you to not apply on time. It can really help you to have it. Um,
I think I was answering the other questions in between there, but if I
yeah.
missed yours somewhere along there, please either type it again or ask it.
Yeah. I think we have answered everything that I see in chat as well. And yeah, thank you everyone for your time today and for your participation. That definitely makes all the difference for us as presenters as well. And definitely reach out to us through Carla if you have follow-up questions, or as Menon said, if you'd like us to do this presentation in a more accessible form to other members of the community, we're happy to do that too. Thank you.
Awesome. Thank you so much, Sarah and Emma, and thank you all for being here. I know it's like right in the middle of like the holiday season. Like we mentioned, we're going to be sharing the slides and the recording from both this training and I think it was yesterday's training. And so we'll be sending those out to the COC and SPN listers, which most of you are part of. And then we'll also be sending a feedback survey, and we'd love to hear how this training went for y'all. And we use that information to improve our next year's training when we do this again. So thank you all so much, and thanks, Emma and Sarah.
Bye, y'all.